This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about what happens to an arsonist who begs an Ohio district court to release him from prison under a compassionate release program, only to find that compassionate release is not available to a convict who only is suffering because he is fat and diabetic. This is because arson-for-profit is a violent crime of the first order, and one that should be entitled to no compassion at all. Of the hundreds of different kinds of insurance fraud schemes, the most violent and dangerous is an arson-for-profit. People and firefighters die or are seriously injured in the fires. Daryl Evans was caught, tried, and convicted of the crimes and is now serving a 183-month sentence for insurance fraud relating to his arson of several properties in Warren, Ohio. Evans moved the USDC in the Northern District of Ohio, in pro se, for compassionate release under 18 U.S.C. Section 3582. In a case called United States of America versus Daryl Evans, the USDC for the Northern District of Ohio on March 6, 2024, determined that Evans was not a proper candidate for compassion. Evans argued that his medical conditions, including his untreated diabetes, hypertension, heart failure, sleep apnea, obesity, and age, in combination with his rehabilitation efforts, were extraordinary and compelling reasons justifying early release. Generally speaking, once a court has imposed a sentence, it does not have the authority to change or modify that sentence unless such authority is expressly granted by statute. However, under 18 U.S.C. Section 3582 C1a, a district court may reduce a defendant's sentence upon a motion from the defendant if the defendant filed the motion 30 or more days after the defendant set a compassionate release request to their warden. If a defendant's compassionate release motion meets this exhaustion requirement, the court then considers three factors in deciding whether to grant the compassionate release motion. 1. The court must decide whether extraordinary and compelling reasons warrant a sentence reduction. 2. The court must ensure that such a reduction is consistent with applicable policy statements issued by the Sentencing Commission. And 3, finally, the court must consider all relevant factors listed in 18 U.S.C. Section 3553. Evans exhausted his administrative remedies, but did not show the extraordinary and compelling circumstances needed for relief. Evans cited his hypertension, heart failure, sleep apnea, obesity, and age as extraordinary and compelling. However, the court noted these medical conditions of Evans existed at the time of his sentencing. Facts that exist at the time of sentencing are not extraordinary, and nor are they compelling reasons for compassionate release. Evans' type 2 diabetes, which the Bureau of Prisons, the BOP, diagnosed in October of 2022, and which the BOP is capable of treating Evans's diabetes or other medical conditions. Evans's medical records showed the court that when he was diagnosed, the doctor recommended a lifestyle modification and to recheck Evans's HA1C at a later date. Evans was given educational materials and assented to his understanding, and his condition improved. Because Evans offered no extraordinary and compelling reasons for compassionate release, the court briefly discussed why, even if Evans had shown extraordinary and compelling circumstances, Section 355A factors stop early release. While Evans's extensive rehabilitation efforts while incarcerated are commendable, these efforts are insufficient to overcome the severity of his crimes. In fact, Evans ordered 3 arsons, two different properties in Warren, Ohio. And of the 2 properties, he put Warren community members at risk of death or serious injury. In exchange, he received $146,000 in insurance payments, an amount he currently owes in restitution. His petition was refused. In my opinion, based on the fact that I have personally investigated several arson fires and advised insurers with regard to many more as an attorney, arson-for-profit is the most vicious and reprehensible variety of insurance fraud. People die in these fires, sometimes even the arsonist, including neighbors, tenants, police, and firefighters. His sentence was appropriate, and it is a shame that the U.S.A. must pay to feed, house, and medically treat Mr. Evans for years. The punishment, however, is appropriate, and he, as an arsonist, is one of the least likely prisoners in the federal system entitled to compassion. He will serve his full sentence in the Gray Bar Hotel. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll be advised of every blog posting, usually 5 or 6 a week. And you will have access to the more than 4,750 blog postings. I'd appreciate it if you would tell your friends and colleagues about this blog and the videos and let them also subscribe. It's free. And if you or your friends are interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee of $50 a year, subscribing to my Substack publications. Thank you for your attention.